comments from the FDA. What's your advice on companies on the statement of identity or how to label their hemp products?
Yeah, I mean, just to start with labeling generally, I mean, it can get really technical and complicated. So it's important to have a good understanding of where you shouldn't stray from the regulation and where strict compliance is more essential. And this can help reduce risk, not just from a regulatory angle, but from a class action litigation perspective as well. And a consultant or a law firm can help, and especially with issues, like implied disease claims, that can be hard to pinpoint. I think, these are really areas where companies need to take a close, hard look. But from a high level, stepping back, despite FDA's position, we as a firm do not recommend straying from the dietary supplement labeling rules, including the statement of identity, or using something like product facts. Because even if you don't call your product a dietary supplement, FDA regulates products based on intended use. And actually, FDA just issued an announcement about updating its intended use requirements and what it looks at when determining intended use. So FDA uses a variety of factors and can determine that your product is still a dietary supplement, even if you don't call it that. Or worse, they could determine that your product is a drug. So putting that statement of identity, identifying your product as a dietary supplement, and following all the rules that go along with marketing your product as a dietary supplement is something we absolutely recommend.
Got it. What is the risk level if a company just wants to have a statement of identity, such as a product facts or an herbal remedy? It seems pretty risky to me.
Yeah, again, because FDA can look to these other factors to determine your product's a supplement, the directions for use, and other factors. So then you have a product that's mislabeled, and again, FDA could determine that your product is intended to be used as a drug. So whatever you can do on your labeling to confirm that your product is a dietary supplement will help reduce risk. And unfortunately, we were talking about states, but I think it was Louisiana that was telling dietary supplement companies to use a product facts,
right,
and not use a supplement facts. And I think that's really a disservice to companies, and I think points to a larger problem of states not really understanding how comprehensive the federal rules are with respect to dietary supplements. And I think, we can go back and forth and you hear folks saying, oh, they aren't robust enough. But the fact is they are comprehensive. They cover all aspects of labeling, safety, claims, substantiation, all of these things. And it's tough when you see other states coming out with rules that either contradict or are duplicative of what's required at the federal level, and sometimes don't even move the needle on safety and consumer protection.
Sure. Yeah, Louisiana is a great extreme example. When I was getting a product registered in Louisiana, I decided not to, because I couldn't bring myself to put product facts on a product. Just it was pretty annoying indeed. I know a lot of people, when you're having a discussion about statement of identity, they'll bring up FDA warning letters where CBD is not a dietary supplement, but then they'll also refer to class actions. Now, several months ago, this was maybe a more applicable discussion. I believe that most, if not all, the class actions out there, Ren, that only listed a hemp CBD product as a dietary supplement and didn't make any other claims, I believe those class actions have either been stayed or have gone away. Is that correct?
Yeah, as the last time that I looked into this, I believe most of those class actions challenging the fact that the products are being marketed as supplements in light of FDA's position have been stayed on primary jurisdiction grounds, citing the fact that FDA has made it clear that they are continuing to examine the regulatory status of CBD, and courts have responded by rightly so by by saying that they're not willing to take up these complicated issues that are clearly more suited for FDA to consider. And then we would have, different courts in different areas of the country having different rules around CBD, which is definitely not what we want, and not what the courts want to be doing.